Hello and welcome everyone to this AI PPI webinar where we're going to discuss the CJU's decision in the BSH Electrolux case and its implications for cross-border patent litigation in Europe. This webinar has been prepared as a joint initiative between AI PPI's enforcement and patent standing committees. I'm Pete Damerell. I'm a partner at Powell Gilbert in London, and I'm chair of AI PPI's enforcement standing committee. I specialise in patent litigation, mainly before the UK courts and the UPC, and the vast majority of my cases have cross-border elements. Before introducing the other speakers, I'm just going to cover off a few housekeeping points listed on this slide. So this webinar is being recorded. If anyone has any questions for the speakers, and we will be seeking to have a Q&A session in the last 15 minutes or so, via the Q&A box. As I said, the Q&A session will be at the end, but please do submit questions as they come to you during the webinar. If you have any technical problems, please send a message in the chat box and they'll come to AIPPI events, and hopefully they'll be able to sort it out. And there is also a brief survey after the webinar, which I think will pop up automatically. And AIPPI would very much appreciate your feedback. So moving on to the speakers, we have a panel of very experienced patent litigators in Europe who are all involved in cross-border patent litigation on a day-to-day basis. I'm joined today by Stefania Bergia from Italy. She heads the IP practice of the Italian office of Simmons & Simmons in Milan, and she's also vice chair of AIPPI's enforcement committee. We also have Koen Bijvank, who's a partner at Brinkhoff in the Netherlands and chair of AIPPI's enforcement committee. And finally, we also have Nevin Öner, who's a partner at her law firm in Istanbul and is vice chair of AIPPI's patent committee. We're very lucky that Nevin is joining us today. There was very sadly an earthquake in Istanbul shortly before this webinar was due to start. But Nevin is on the line at the moment and hopefully will kind of retain internet connectivity during the webinar. Okay, I'm going to now share my slides. Let me just make sure I've got the right ones. Okay, good. Hopefully those are now showing for everyone. So as I mentioned, we are going to discuss the CJU's decision in the BSH and Electrolux case, which is a very significant development in the approach to cross-border patent litigation in Europe. I've seen a number of reports where people have made comments along the lines of how this decision opens the door to cross-border litigation in Europe and other such sorts of themes. It's certainly a very important decision, but we should bear in mind that there have always been cross-border litigation in Europe. It's not a new concept. We're going to discuss a little bit about the approach to cross-border litigation in the Dutch and the Italian and the UK courts, for example. But this new decision from the CJU builds on earlier CJU decisions such as Gatt and Look, Roche and Primus, and Solvay and Honeywell. And it's certainly a very significant development. And in particular, as we'll discuss, it really kind of provides a development and clarity on how invalidity defences and counterclaims are dealt with in cross-border litigation, and also has potentially very significant ramifications for dealing with non-EU patents in EU member state courts. This webinar is a precursor to a fuller discussion on this topic that's going to take place at the AIPPI Congress in Yokohama in September. And so really, we're just going to outline the decision, have some initial discussions on the implications on likely approaches of both some EU courts and some non-EU courts, and then finish up with a Q&A. So just to outline the session, Stefania is going to start by providing an introduction to the CJU's decision. Koen is then going to discuss how the UPC has dealt with the decision so far, because the UPC, as far as I'm aware, is the court that has actually looked at it and implemented it so far. We're then just going to look at two examples of EU courts, courts of the Netherlands and Italy, and discuss how this fits in with their existing jurisprudence and how they may apply the new decision. And then we're going to look at potential approaches of some non-EU courts, in particular the UK and Turkey, and how they may respond to these developments in the EU. And then we'll finish up with a Q&A session. So right, I'm going to hand over to Stefania to introduce the decision for us.
Thank you very much, Peter, for the introduction, and good morning or good afternoon to everybody. So I have not used any drawing in my slide, only some colors, and hopefully these will help you in following better the slide. So what are the facts behind this case? The facts are the following. BSH is a German company, the plaintiff, which holds a European patent validated in several EU member states, in particular 6, and in a third country, Turkey. BSH has started an infringement action against Electrolux in a Swedish company before the Swedish court on the basis of the jurisdictional criterion of the forum rei, according to Article 4.1 of the Bruxelles 1 bis regulation. BSH has alleged the infringement not only of the Swedish portion of its patent, but also the infringement of the foreign parallel portion of the same patent. And BSH has therefore asked for the injunction in all these countries pertaining to the foreign portion of the patent and compensation of damages. The defense of Electrolux was, first of all, the validity, the patent is not valid. And then Electrolux raised an objection of lack of jurisdiction of the Swedish courts for the infringement of patents validated in countries other than Sweden. In particular, Electrolux said, when patent invalidity is raised, and in this case, Electrolux raised, as we said, an objection of invalidity of the patent. So Electrolux said that when patent invalidity is raised, then the infringement action must be regarded as a dispute concerned with the validity of patents within the meaning of Article 24.4 of the Bruxelles 1 bis regulation. And therefore, according to this article, only the courts of the member states where the patent was validated would have jurisdiction. You know that according to this Article 24.4, there is an exclusive jurisdiction of the courts of the member states where the patent is validated. So this was the defendants of Electrolux, lack of jurisdiction because invalidity defense was part of the infringement proceedings. What was the position, at least in first instance, of the Swedish court? The position was, Electrolux, you are right. So the Swedish court in first instance recognized that they had no jurisdiction to hear the action for infringement of patents validated in member states other than Sweden and validated in third countries. And they stated that they had no jurisdiction, recalling the Article 24.4 of the Bruxelles regulation, and they recalled this article also with regard to the third country, with regard to the non-European countries, so with regard to Turkey, because they said this article 24.4 is an expression of a principle of jurisdiction recognized at international level. BSH did not surrender. They appealed the decision, and they stress that they were not applying for an invalidity action. They were they started a patent infringement action, a pure patent infringement action, and that a court seized on the basis of Article 4.1, so on the basis of the forum rei criterion, may hear an action alleging infringement of a foreign patent, even if it does not have a jurisdiction to rule on an action for a declaration that the patent is valid. The Swedish Court of Appeal decided that this was a really very complex matter and decided to stay the proceedings and submitted a preliminary question to the ECJ. Let's see the preliminary question that I have reported in the following slide. I have highlighted in yellow the preliminary question. The first one is reported here literally, so it's rather complex, but the meaning of this first question is Article 24.4 of a Bruxelles 1 bis regulation, because all the preliminary questions were focused on the interpretation of Article 24.4 of the Bruxelles 1 bis regulation. So according to these first questions, the ECJ was asked to answer to the following question. Is Article 24.4 of the Bruxelles 1 bis regulation to be interpreted as meaning that that a national court, I can simplify, that a national court which, pursuant to Article 4.1 of that regulation, has declared that it has jurisdiction to hear a patent infringement dispute, no longer has jurisdiction to consider the issue of infringement if a defense is raised that alleges that the patent as at issue is invalid, or is the provision to be interpreted as meaning that the national court only lacks of jurisdiction to hear the defense of the invalidity. So there is these two possible interpretation of Article 24.4, and the court, the ECJ, responds in the following way. Article 24.4 constitutes an exception to the general rule provided by Article 4.1, instituting the forum rei, and must therefore be interpreted strictly. So a strict interpretation of the exclusive jurisdiction provided by Article 24.4 as being applicable only to proceedings directly concerned with the registration of a validity of a patent, and not to infringement action, even if the validity is a challenge as a defense therein. So you can easily understand that already from this first part of the response, is clear that the ECJ recognized that the position of BSH was correct. So the consequent statement was that a national court seized of a patent infringement action does not lose, so keep in mind, does not lose jurisdiction over infringement merely because the validity of the patent is challenged as a defense. But, so there is a but. So there is jurisdiction, but the court, in our case, the Swedish court, may stay the proceedings if, first, invalidity case is duly brought in that respective member state and /or, and we could discuss lengthily about the meaning of and /or, but in any case, let's try to be simple. So the condition is, one, invalidity case is duly brought in that respective member state. Second, the court consider it justified, in particular where there is a reasonable, non-negligible possibility that the patent is declared invalid. So according to this first response, 24.4 is an exception. When there is only an objection of invalidity raised during an infringement proceedings, this does not mean that the court is not allowed anymore to evaluate the infringement only because there is this invalidity objection. Okay, so and why? And we will see also other reason that can explain why the court seized for the infringement can evaluate incidentally the nullity, because at the end the nullity will be considered by the national court only within the context of an infringement case, and there will be no effects erga omnes with regard to the validity of the patent. The patent will not change the content of the patent, and the effects of the decision will be only inter partes. So let's see. This is more or less the meaning of the first answer. Let's see the second question. The second question is, but the answer to the question 1, so the interpretation of 24.4, is affected by the national laws, and in particular, if national law contains a provision according to which, for a defense of invalidity arising in an infringement case to be heard, the defendant must bring a separate action for declaration on invalidity. And this was significant for this specific case because according to the Swedish Patent Act, the defendant must bring a separate action for a declaration of invalidity. And the answer of the ECJ was again very clear. And they said, no, national procedural rules do not affect the interpretation of Article 24.4, which is an autonomous concept of EU law and must be interpreted uniformly across all member states, regardless of internal provision. And then we go to the third question, which is very interesting because it is connected to the so-called third country, in particular to the non-EU member country, which in this case was Turkish. And so the third question submitted to the ECJ was the following: is Article 24.4 to be interpreted as being applicable to a court of a third country, also conferring exclusive jurisdiction on the Turkish court for the Turkish part of the European patent? And the answer of the ECJ was no. I mean, Article 24.4 does not apply to courts of third states and does not confer any jurisdiction on them regarding the validity of a patent granted or validated in those countries. However, and this however is very relevant, it follows from the internationally recognized principle of non-interference that only courts of a third state in which a patent is granted or validated have a jurisdiction to declare the patent invalid by a decision that may cause a national register for states is seized as a forum rei for an action alleging infringement of a patent granted or validated in a third. Sorry, I have read and maybe not so clearly this sentence, but in any case, they said 24.4 does not apply to court of third countries, but in any case, to these third countries, you can apply a principle, an international recognized principle of non-interference. On the basis of this international recognized principle of non-interference, what is the consequence? The consequence is that if a court of a member state is seized as a forum rei of an action alleging infringement of a patent granted or validated in a third country in which the question of a validity of that patent is raised as a defense, that court has jurisdiction, pursuant to Article 4.1 to rule on that defense, but its decision in that regard does not affect the existence or the content of the patent in third state. And the Lugano Convention and other bilateral conventions do not cause any restriction. A court can give inter partes ruling. So this is again the core meaning of all the entire decision. Court can give inter partes ruling on the invalidity defense in the context of the infringement action. So you will have time to digest, I'm sure, better these questions, but I can and maybe Peter, if we can skip it to, thank you. You can maybe digest better this question, but the content is clear. The ECJ clearly said BSH is right. The Swedish, in the particular, I mean, of course, the ECJs dictated the general principle, but the consequences was that in this specific case, the Swedish court will be considered competent to evaluate the infringement and to consider incidentally the invalidity defense, because the invalidity is not the core of the action, because of course, if you have to decide about the validity of the patent, you have to go to you have to follow the exclusive competence of the member states where the foreign patents have been validated. But in any case, the court, in this case, the Swedish court, will be able to evaluate the infringement with regard to all the portion, even if a defense of invalidity has been raised. The slide said, what are the implications? The implications are many. We are patent litigators. We are here all patent litigators, so we are very interested by this decision because the strategies can be strengthened. Strengthen both before EU courts, both and before the UPC, and Koen will discuss about now the possible consequence before the UPC. We have already seen some decision which made reference to this important ECJ decision, and we will also discuss about possible action to prevent these wide cross-border actions. I think that I have respected my time, hopefully.
Thank you very much, Stefania. That's great. So I think if you agree, I think the big take home is that we're likely to see more cross-border infringement decisions taking place in the courts of a defendant's domicile, and that the onus is then on the defendant to bring proper invalidity actions in the courts of other countries. But so essentially the defendant can't scupper a cross-border infringement action by raising invalidity as a defense, and it's going to lead to more cross-border actions going on.
Yes, and I must confess to all the auditors who have joined us today that Peter, with regard to this slide, asked me, but why you have not added to the first point A also a reference to the fact that according to this decision now we could also most probably ask for an injunction not only with regard to EPC member countries, but also with regard to the US territory. And the answer is yes, it could be. It could be that we could try to extend a request to also to the US territory. And well, I have not put it down here in this slide because maybe someone could accuse us to be to follow an imperialism strategy, let's say like this.
And I explained to Stefania that I wasn't worried about being accused of following an imperialist strategy because I'm from the UK and we're constantly accused of that. But anyway, thank you very much, Stefania. Let's move on to Koen, who is going to give us an overview of how the UPC has responded to the BSH decision so far. Because as far as I'm aware, it's just the UPC that's considered this decision, although there may be a few national courts that I don't know about. Anyway, over to you, Koen.
Thank you very much, Pete, and also to you, Stefania, for laying the groundwork, if you will, and setting the scene and explaining the intricacies and the questions of the BSH decision. So the UPC, of course, is a very recent development, although almost 2 years in operation. But actually, the UPC is already, of course, a forum where cross-border decisions are granted by definition, because it's a common court for a number of countries within the EU. And actually, this being a novelty, the UPC was quite quick off the mark, and already before the decision was handed down in the BSH case by the CJEU, there is a decision where what we call long-arm jurisdiction, or if you will, cross-border jurisdiction, was accepted. And that's the case that's on the slide in front of you right now. It's a decision from the local division in Düsseldorf in January, so that predates the BSH decision by about a month. And in that case, there was a patent that was a European patent that was in force in both the UK and in Germany. And it was invoked against a number of defendants. And this decision deals with the German defendants. There was a counterclaim for revocation of the German part of the patent. And nonetheless, the local division in Düsseldorf accepted jurisdiction also for the UK designation of the patent. And that was very much based also on the same reasoning as in BSH, because the German defendants are domiciled in a member state, and the UPC is a common court for the member state. So as such, it functions as a German court for the purposes of Article 4 of the Brussels regulation. And that therefore meant that the UPC found itself to be competent to also give a decision for infringing acts by these German defendants that would have been carried out in the UK. It didn't turn out that way because the court came to the conclusion that the patent is to be revoked, of course, only for Germany and not for the UK. And that was the reason why the injunction was ultimately denied. The court could have come to a different view potentially for the UK. It acknowledged that the case could have been different, but in the case itself, the claimant, Fuji, did not explain why the assessment of validity would be different under UK law than it would be under German law, which of course makes perfect sense because the substantive law where it concerns validity of patents, European patents, is very much harmonized on the basis of the European Patent Convention. So on that basis, the UPC accepted jurisdiction, made an assessment of the validity, and that meant that an injunction was to be denied for both Germany and the UK. The court also acknowledged that there is an option of staying the case, at least for the UK, because it did not have competence to adjudicate ultimately the validity of the UK part of the patent, but it decided not to because there was no UK revocation action pending at the time that it rendered its decision. So that very much ties into what Pete and Stefania already mentioned, that if you want to prevent a court, a European court, including the UPC, from accepting jurisdiction and proceeding and adjudicating a case also for countries that are outside of the territory of that court, in this instance the UK, then the onus is on you as a defendant to start something and to start a revocation action. And in the absence of anything like that, the court may proceed as in fact it did in this case. Next slide, please. Yeah, thank you. So also after the CJEU decision, there are two orders of the UPC dealing with cross-border jurisdiction. And these are orders and not decisions. And that is because of a peculiarity of the UPC system that allows defendants within a month after an action has been started to file a preliminary objection. And the preliminary objection procedure is meant to dismiss cases that are, as you might say, bound to fail. And there is a limited number of grounds that you can invoke in support of a preliminary objection. And one of them is competence or jurisdiction of the court, of the UPC. So this cross-border jurisdiction or long-arm jurisdiction of the UPC is an issue that can, of course, and is in fact raised in the context of a preliminary objection. And one example is this case where the local division in Paris decided about a month after BSH in a case where the defendants were of French and Swiss nationality. Switzerland, of course, is not a member state of the European Union, but essentially the UPC accepted that it could apply a similar approach for the Swiss entity as it could for the French co-defendant on the basis of Switzerland being a member of the Lugano Convention, which essentially extends all the provisions of the Brussels regulation also to Switzerland in this case. The preliminary objection specifically dealt with the Spanish, Swiss, and UK designations of the patent. All three jurisdictions are not part of the UPC territory. Spain is an EU member state, so the Brussels regulation directly applies. Switzerland and the UK, of course, are not. And for Switzerland, the Lugano Convention could be invoked. But for the UK, that's clearly a territory outside of both the European Union and the effect of the Brussels I regulation. The local division in Paris accepted jurisdiction nonetheless for all three designations of the patent. It also acknowledged that it could be that an action might be stayed if there would be a national revocation action, which was not yet the case when it decided on the preliminary objection. It also, essentially referring to the third question in the BSH decision, held that it could decide validity, at least with inter partes effect, for the UK. Remember, the UK is not a member of the EU, so Article 24.4 doesn't directly apply to the UK. Nonetheless, on the basis of this internationally recognized principle, the UPC would not go as far as to revoke the patent for the UK, but it held that it could decide the validity of the patent also for the UK, and if it would come to the conclusion that the patent is invalid also for the UK, then that would at least have an effect for the parties in the case. Next slide, please. Similarly, even more recent, just 2 weeks ago in Milan, the local division in Milan also applied the CJEU decision in a case where there were 6 defendants, and one of them was an Italian defendant, filed a preliminary objection, also contesting the competence of the UPC or jurisdiction of the UPC over the Spanish designation of the patent, and applying similar reasoning as the local division of Paris did in the case that was on the previous slide. It came to the conclusion that it could proceed also with the case against the Italian defendant being domiciled in an EU member state, also for the designation Spain. And it explicitly held, which of course makes sense because it's stated in Article 71A of the Brussels I bis regulation, but it acknowledged that the UPC is a court of a member state and therefore could apply Article 4 of the of the Brussels I regulation directly. So this already shows that the UPC can act quickly, is ready to adopt the development of the BSH decision, and will accept long-arm jurisdiction. Of course, it will be slightly different from some of the possibilities that Stefania mentioned. This being the UPC and being bound to the UPC agreement, it will not be able to adjudicate cases where non-European patents are at stake, because the UPC agreement clearly limits the powers of the UPC to deal with European patents only. So that will be up to the national courts. And with that, I think I can turn to the Netherlands, my own jurisdiction, where we actually have quite a long history dealing with cross-border injunctions for patents, but also outside of patents and IP. And this all arises from a principle that was adopted or formulated by our Supreme Court already in 1989, and that is that our courts can order parties to perform acts or refrain from acts, therefore also an injunction, even when those acts have to be considered under foreign law. And that case, Lincoln Interlas, concerned a trademark case, but this has, of course, effect beyond intellectual property. Essentially, a party should be sued before their home court, but if they have committed a tort outside of their home country, somewhere else, then they could still be sued before their home court and be held liable for activities that they have carried out outside of the territory of their home court. And in situations such as that, the Dutch courts will apply foreign law and will allow themselves to be educated by the parties of what that foreign law is and how it should be applied to the facts. But in the end, they will decide then the case under foreign law. And this principle is most easily applied, of course, to a defendant for which the Dutch court is the home court on the basis of Article 4 of the Brussels I bis regulation, but our Dutch Code of Civil Procedure has a similar provision that parties can, of course, be sued before their home court. But the courts have also quite frequently accepted jurisdiction over foreign defendants on the basis of Article 1 of the Brussels 1 bis regulation and a similar provision in the Dutch Code of Civil Procedure, where if there is sufficient connectivity between the activities of the Dutch defendant and the foreign defendants, if they're all in it together, if you will, then the courts will accept jurisdiction also over the foreign defendants, simply because it's efficient and it avoids contradictory decisions from various courts. So on that basis, there are quite a few examples, and this is usually in our case law where the biggest fights are, where it comes to jurisdiction of the Dutch courts to grant cross-border relief. Next slide, please. So for patent cases, we have, of course, Article 24.4 of the Brussels 1 bis regulation that held that member states have exclusive jurisdiction to decide on validity. So the question then has arisen in the past quite frequently how to deal with situations where the defendant, the accused infringer, raises an invalidity defense or files a counterclaim for revocation. And on the basis of by now quite old or quite established case law from the Court of Justice of the EU, our courts have held that certainly in cases where provisional relief is at stake, so a preliminary injunction case, then Article 24.4 does not preclude the court from proceeding and from granting an injunction, because there is no question under the Solvay-Honeywell case that the Dutch courts can have jurisdiction about infringement, so the liability. There is no counterpart for Article 24.4 for validity for liability for infringement. And in a PI case, the courts will, of course, not decide definitively on the validity of the patent, but in our preliminary injunction framework in the Netherlands, even if it's just a case that is restricted to the Dutch territory, the injunction will be denied if the preliminary injunction judge comes to the view that the patent is likely invalid. And the wording that has been adopted in our case law is whether or not there is a serious non-negligible chance that the patent would be revoked in a revocation action or in EPO opposition proceedings. And that wording is very similar to the wording adopted by the Court of Justice of the EU in the BSH Electrolux case. So from a Dutch perspective, it is perhaps an extension of the case law that was already in place. But on the basis of Solvay-Honeywell, at least in preliminary injunction proceedings, the courts have been quite willing to grant cross-border injunctions. And they've also done the same in the context of merits proceedings, where the injunction is requested on a provisional basis. So it would not be a permanent injunction, but a preliminary injunction that would remain in place, provided that the court is convinced that there is not this serious non-negligible chance that the patent would be invalid. That would remain in place as long as the patent is not revoked in a merits revocation action in the other countries, in the foreign countries. So that again places the onus on the defendant, on the accused infringer, to start these revocation actions in all these countries in order to get the injunction that has been granted by the Dutch courts removed. That is a little bit the history. So how then do we as Dutch lawyers look at the BSH decision? Like I said, actually, I think we all see it more like an endorsement of Solvay-Honeywell that opens the door to do similar things that we are quite accustomed to on a provisional basis in a PI case, also on a more permanent basis. So no longer limited to a provisional order. And now our courts, we think, will be able and will probably also grant permanent injunctions if they are, again, convinced that there is a reasonable and non-negligible chance that the competent foreign court will not revoke the patent. And if they have doubts as to the validity of the patent, then of course they will not grant the injunction, and the same procedure might apply as what we're used to already from before BSH, and that is that the case may be stayed pending the outcome of a foreign revocation action. And if that is never filed, because if the injunction is denied, then perhaps the defendant does not have so much of an incentive to start these revocation actions, then the case may remain pending for quite a long time but then that, of course, doesn't really affect the accused infringer. Like what we saw in the preliminary objection order from the local division in Paris in the UPC, on the basis of BSH, it seems to me that the Dutch courts should also be able to decide on validity, at least on an inter-partes basis, of non-EU patents. And this not being the UPC, this could extend to also non-European patents, like national patents in Europe, or maybe even US patents or Chinese patents. And of course, this would not have an erga omnes effect. It will not affect the register in the foreign country, but it would create a bar on probably the claimant, the patent owner, to invoke that patent again against the same party. It will be a question, I think, for the future to see how these foreign courts will deal with a Dutch finding that is limited in its effect to the parties in the case as to the invalidity of the patent, how that would affect the outcome of national proceedings in that other country. Yeah, I mean, that would, of course, not be something that the Dutch courts would be worrying about, most likely. Next slide, please. So I think the practice will continue as it was, just perhaps as a bit of background. Most cases, of course, will involve not just Dutch defendants, but quite frequently also other defendants from foreign countries. In order to create cross-border jurisdiction, it will be necessary that there is at least a defendant domiciled in the Netherlands that is part of the infringing acts, and the foreign defendants that can then also be included in the case would have to be involved in the same activities. And we have examples in our case law where this is not only based directly on patent law, but also on general tort. There are a few examples where Dutch entities have faced cross-border injunctions to facilitate patent infringement in other countries by making available a market authorization for a drug, for instance. That would mean that there is infringement outside of the Netherlands, maybe not even in the Netherlands, because the product may not even be on the market in the Netherlands. But the Dutch entity holding the market authorization facilitates infringement by, for instance, a German company or a Spanish company by relying on a centralized market authorization to bring that product on the market in Spain or in Germany. And then the Dutch courts can put an end to that by granting an injunction against the Dutch entity to make available that market authorization. And without access to the market authorization, of course, it would be impossible to market the drug, to continue to sell the drug in those other markets. And also interesting to note that our Dutch courts are also quite happy to accept jurisdiction in cases where not even a Dutch patent is at stake. The Longi Hanwha case that is on the slide, it's a decision from our Court of Appeals in March 2022, so quite a while ago already. It was based on a European patent that was not in force in the Netherlands. The defendant, Longi, acted as the distributor for all of Europe. So the solar panels, that's what the case was about. The solar panels were imported into the Netherlands and then distributed across Europe. And therefore, Longi Netherlands was involved in infringement across Europe, and that was sufficient for the Dutch courts to grant an injunction in the Netherlands with cross-border effect. So it seems to me that on the basis of BSH Electrolux, we will probably be seeing more of that, probably because our courts are quite used to dealing with these types of situations already. And I think that's what I wanted to discuss about the Netherlands. Thank you.
Thanks very much, Koen. I just had one observation and then two questions I wanted to spring on you, Koen, and apologies for that. Just to start with the observation, and that was really just to say, you know, the CJU judgment in BSH is very much focused on Article 4 jurisdiction, so defendants who are in, and where their domicile is. But I think the Dutch case law is really interesting to bear in mind, you know, the implications for Article 8 and bringing in other foreign defendants. And it's, you know, you don't really necessarily think about that when you're reading the BSH decision, but it's, you know, the Dutch approach really highlights actually how this is likely to develop across Europe. Just on the questions, the first one was to do with these words, reasonable non-negligible possibility of the patent being declared invalid. And you mentioned the Dutch courts are very familiar with those in the context of the cross-border PIs. Is that it? Can you give us any sort of feel of how high a burden or how that test is generally applied by the Dutch courts? Is it quite difficult to persuade the Dutch court that there is a reasonable possibility of a patent being declared invalid? And are there any sort of particular invalidity arguments that are better suited to that?
That's an interesting question, because the wording used by the courts in their decisions will be different in a PI setting from a merits case. Whether or not in practice the test is so very different is really hard to say. I would say that in a PI case, perhaps the courts are more likely to accept validity if there is, for instance, a decision from the EPO opposition division, more so perhaps than in a merit situation. On the other hand, you would think, and I think that's the intention of the wording, that's why the wording is chosen, the bar should be a little bit higher for the patentee to overcome that validity defense before an injunction is granted. It's a PI, there's only room for a preliminary assessment, and you would think that if there are doubts, then the injunction is withheld and then fight it out in merits proceedings. However, the way it really plays out in preliminary injunction proceedings is that it is quite detailed. It is almost like a mini trial on the merits, and there will be expert opinions, and there will be prior art, there will be added matter objections, there will be novelty inventive step, everything. So in practice, the differences aren't perhaps so great as the wording would seem to suggest.
Great, thanks, Koen. That's helpful. My second question was more about whether the Dutch courts historically have looked at the validity of non-EPs. So, I mean, the situation seems relatively straightforward, where you've got one EP and you've got different designations, and I can see that it's relatively straightforward for a court to consider all of those designations. Is there a practice so far in the Dutch courts of actually going beyond that and looking at US patents or national patents, something that's a bit different?
I know of one example where a Portuguese national patent was at stake. It was a case against Teva. Teva Europe was the MA holder and provided access to that MA to a Portuguese entity. Infringement proceedings were pending also in Portugal, but the patent owner, Bergia Ingelheim, was of the view that that was taking too long. So they decided to sue Teva Europe in the Netherlands on the basis of a tort, so not patent infringement, but in the end, the court had to deal with both validity and infringement under Portuguese law, assessing whether or not the Portuguese entity infringed the patent under Portuguese law, because that was, of course, a condition for there to be a tort by the Dutch entity making available the market authorization in Portugal. So in that case, the court was educated by the parties on Portuguese national validity law. In particular, the case dealt with what we would call under European law a 54.3 publication, so a document that was not published before the filing date, but had an earlier filing date. And it turned out that under Portuguese law, those earlier patent applications could also be relied upon for inventive steps. So that was really different from the regular framework of a European patent. And nonetheless, the Dutch courts did not hold back and granted a cross-border preliminary injunction.
Very interesting. I think that's an area where we might see a lot more development, particularly with these non-EU patents, given the answer to the third question. So it'll be interesting to keep an eye on that. Brilliant. Thank you very much, Koen. Let's move now to Italy. And over. Sorry, Nevin.
Before moving to Italy, I also have one question for Koen. But don't you think there is a big difference between US and Portugal? Because, I mean, Portugal is a EU member and there are some international conventions. But when it comes to US or China, do you think, is there any convention that we can say that the European courts are entitled to handle the case?
Well, I think it would be the Dutch Civil Code of Civil Procedure that creates jurisdiction against the Dutch defendant. And if that Dutch defendant is committing a tort, such as patent infringement, somewhere in a foreign country, that could be the US or Turkey or China, then I think the courts would accept jurisdiction and would have to apply foreign law to think about infringement and validity. I'm not sure if it's likely that you would sue a Dutch company for patent infringement carried out in the United States, but I think it would certainly be possible. I don't know of an example, and I cannot, from the top of my head, think of any further legal basis that would be required for the Dutch courts to be able to do so. I mean, it's to me sort of similar to going on vacation and being in a car accident and being liable, and then you have breached the traffic laws in that foreign country, and you can still be sued before your home court, and that home court would have then to apply foreign law to assess whether or not you're liable. And I think this is pretty much the same.
Yeah, I agree. But do you think this decision would be enforceable in the US or in China?
That's a different question, of course, and that has to do with whether or not the Chinese courts or the United States courts would recognize a decision from a Dutch court, and that may be more difficult, and that will be dependent on all sorts of treaties that the countries are a member to. That, of course, is much easier within the EU because their decisions have to be recognized mutually. So that's a different question. For, I think, patent infringement, that doesn't necessarily arise so much in practice, because if you have a cross-border injunction granted by a Dutch court against a number of defendants in the Netherlands, then a breach of the injunction means that you forfeit penalty sums, and you can enforce the decision again through the Dutch courts. And if there is a Dutch defendant involved, then they have assets in the Netherlands that you may be able to seize in case the penalty sums aren't paid. So there would be mechanisms in place that you can make use of without having to resort to execution or enforcement of the decision in that foreign country.
But how the court will decide whether the preventive decision is like the defendant obeys the preventive decision or not? Because if the court says, okay, don't do this, and how the claimant will prove that the defendant doesn't obey this judgment?
Well, under Dutch law, if there is a judgment granting an injunction, then if the patentee is of the conviction that the infringer continues the infringement, then they simply notify the infringer and claim penalty sums. And if these penalty sums are not directly paid, then you go back to the court that rendered the judgment and ask the court to, force the defendant to pay the penalty sums. So there is a mechanism under Dutch law that you can apply.
Yeah, thank you both. It certainly highlights the potential issues down the line of courts like the Dutch courts, US patents or Chinese patents, but I think it's something we're going to see a lot more of and have to grapple with in the future. Brilliant. Let's move on to Italy and back to you, Stefania, to give us a little bit of an overview of the approach to cross-border litigation in Italy and how you think the BSH decision might impact on that.
Yes, thank you, Pete. Koen has told us about the longer tradition in the Netherlands with regard to cross-border injunction. I would say that we have a longer tradition as well, but not for cross-border injunction, but for cross-border DNI. I mean, because we have numerous cases concerning the so-called Italian torpedo. I'm sure that all of you have already heard about this strategy because it's really a patent strategy in order to stop possible action of the owner of a patent trying to obtain cross-border injunctions. So it's basically a request for a non-infringement declaration of a patent, and not only of the Italian portion of the patent, but of all its national portions, filed by an alleged infringer in Italy, based on the locus commissi delicti criterion and not on the basis of the forum rei. So according to the lis pendens rules contained in the Brussels and Lugano Convention, the first member state court seized in a matter with a pan-European application has the right to retain exclusive jurisdiction. So it's clearly a defensive action filed by an alleged infringer in order to try to take advantage from the delay in some Italian courts to stop a patent infringement action filed against the alleged infringer in a faster EU member state court. So it could be a way to start in advance this kind of action in order to stop a possible cross-border injunction request coming, for example, from the Netherlands, as Koen has just told us. So it's a useful tool, regardless of the jurisdiction of the Italian courts or the chances of a success of the merits. Because why I'm saying that it's a useful tool regardless the chances of success of this kind of action. Because honestly, there is a fluctuation in case law about the admissibility of this DNI action. There are many decisions against the admissibility of this kind of action because the judges in those cases maintain that the interpretation of the jurisdictional criterion of the locus commissi delicti has to be interpreted in a strict way. And just to give you an example of what I'm saying, for example, in a decision of the court, in a recent decision of the Court of Turin, they said, since in Italy the foreign fraction of the European patent does not have legal effect, therefore there can never be an infringement of that legal title. And therefore there is not space for the forum commissi delicti criterion, okay? And according to this case law against this action, they also said, well, but when patent validity issues are raised, are also connected to the DNI, so to the declaration of non-infringement action, then there is an exclusive jurisdiction of the state where the patent is filed. So in this sense, I think that in this direction, I think that the ECJ decision could be, the BSH, I mean, ECJ decision could be of help because we have just examined the decision, and in that decision is clearly stated that even if a patent invalidity objection is raised, then it doesn't mean that the national court loses its jurisdiction over the infringement action, infringement/non-infringement action. So in this direction, the BSH new judgment could be helpful to go against this negative Italian case law. And then there is also a part of a case law, in particular a case from the Italian Supreme Court, is dated 2013, which seems, let's say, in favor because it has recognized the jurisdiction over the non-Italian portion of a patent, and they in particular the Supreme Court recalled an ECJ decision. But I mean. I think that on the basis of the new decision, there could be more space to try to use this strategy because, as I said, it could be definitely used to overcome the patent validity objection cited by the negative decision issued by the Italian courts. And so I think that we can wait for new initiative to preemptive cross-border action for non-infringement. And I would also to add that so far the case law based on this DNI action was to took into consideration cases started on the basis of the locus commissi delicti criterium. But then we could now think about a new trend of cases of this kind of DNI cases started on the basis of the form Ray criterion, and so I think that it could be really a good way to try to revitalize, let's say like this, revitalize this Italian torpedo. But we can also think about positive requests. I mean, not DNI requests, but a request of a cross-border injunction, just as the request tackled by Koen, by the Dutch case law. Why I'm saying that maybe there is a good space to start these cross-border infringement actions, because first of all, the judgments on the merits, the Italian judgments on the merits now are much faster, because there has been a very important procedural reform, which is called Cartabia reform, and therefore I think that this could be helpful to try to ask for these cross-border infringement injunction. And then we have mentioned also the recent UPC decision of the local division of Milan in the Dainese Alpine Star case, and I think that surely also this decision, although issued by the UPC, but I stressed by the local division of Milan of the UPC. So I know that the president judge and the judge rapporteur were Mr. Perrotti and Mrs. Zana. So I think that in some way this UPC decision from the local division of Milan can enlighten also the national case law and act as a booster for the new judicial initiatives. I think that I have ended. Yeah.
Brilliant. Thank you very much, Stefania. So I think one of the greatest impacts of this decision is likely to be the extent to which EU courts will address infringement and validity of non-EU patents. And this is potentially very wide-ranging. Both, this could potentially include both within Europe, such as the UK and Turkey, but also potentially patents outside Europe, as we've already mentioned, such as US, Canada. And I think it's interesting to consider how those courts might react to these developments. And I'm just going to say a few words about the UK and this question of how the UK courts are likely to react to an EU member state court ruling on the infringement and validity of a UK patent. And I think it's fair to say that the initial reaction was really, well, that's outrageous. How dare they be looking at the infringement and validity of a UK patent? But actually, if we step back and look at how the UK court has viewed its own jurisdiction in relation to non-UK patents, then I think it leads to a slightly more measured reaction. Certainly, the UK courts have considered that they have jurisdiction to rule on the infringement of non-UK IP rights in certain circumstances. We had a Supreme Court decision in Lucasfilm, which related to US copyright, where the UK courts decided they could make decisions about US copyright infringement. That's a slightly different scenario in that they're not registered rights. But then we also had Activist and Lily in the UK, which was specifically looking at infringement of the EPs. And it's an indication, at least, that the UK courts have been willing to consider infringement or non-infringement of non-UK patents where no invalidity arguments were raised. So in this Activist and Lily case, activists started proceedings in the UK seeking a DNI for French, German, Italian, Spanish, and UK designations of an EP. But importantly, activists undertook not to challenge the validity of the non-UK patents. Now, Lily is a US company, so this was assessed under the general common law principles in the UK. It wasn't looking at it under the Brussels regulation. And Lily didn't actually challenge the fact that the UK court in principle could look at and determine the infringement of these foreign patents. And the issue actually in that case really related to one of a procedural issue as to whether Lilly had, or whether Lilly's UK lawyers had consented to accept the service of the claim. But I think it at least shows that the UK courts think that they are able to look at infringement of foreign patents, at least when invalidity is not raised. The issue of invalidity is more complex, and I think it's fair to say that the English courts are very reluctant to accept jurisdiction to hear or determine disputes concerning the validity of foreign patents. Now, I'm not aware of any cases where there's been a direct challenge where somebody has brought an action specifically seeking the invalidity of a German or a US or a Chinese patent. Where this issue has arisen is really in kind of royalty dispute cases, where and these two on the slide are examples where issues have come up as to whether royalties are due under foreign patents. And then defendants have said, well, look, I want to make an argument that this US patent, for example, no royalties are due because the patent's invalid. But the questions, the invalidity issues tend to be quite tied up with infringement, and really they're kind of more about scope of claim and those sorts of points. But there's some interesting commentary in the cases. So in the Chagai case, this was a first instance decision. And the case was dismissed for various reasons, but the judge went on to address this specific question of whether the UK court could rule on the validity of a foreign patent. And the judge in that case said that in his view, there were powerful arguments that such direct challenges are not justiciable in the UK, and commented that, you know, their patents are local monopolies, their effect is territorially limited, and their validity should be matters for the local judges of the country in which the patent right was first created. There was then a subsequent case, the GW Pharma Otsuka case, where the Court of Appeal agreed with these statements and held that a direct challenge to the validity of a foreign patent is not permitted, and the court has no jurisdiction to determine a claim that the foreign patent is invalid. So although it's been very rare really for parties to try and invalidate foreign patent rights in the UK courts, when these issues have come up in the context of other disputes, there's a pretty clear indication that the English courts don't, or think that they shouldn't be looking at validity of foreign patents. So how are the English courts likely to react? I think the English courts are going to consider that there are jurisdictional and comity concerns with an EU member state court ruling on the validity of a UK patent, albeit if it's just at an inter-parties level. But I think the question is how this is all going to play out. And so if you have an action in an EU member state court that asserts infringement of a UK patent and the defendant asserts that the UK patent is invalid, under BSH, the EU member state court could rule on that with the inter-parties or with the patent validity question being just dealt with on an inter-parties basis. But then what would happen if there were also an action in the UK court where a revocation of that patent was sought or a DNI was sought? I think certainly one thing that's likely to happen is that the UK action is likely to get expedited to try and come on as quickly as possible, and certainly before the decision of the EU member state court. Now, we're seeing UK cases being expedited for all sorts of reasons, particularly in the FRAND space. And so the UK courts are certainly not shy in expediting UK cases when they think it's necessary. If that UK action was second filed, would there be a challenge to the UK jurisdiction? So would the party that started the case in the EU court try and say, well, look, at least the infringement issue is already being dealt with in the EU court, and so it shouldn't proceed in the UK court? And then we'd have to look at the UK jurisdictional rules on forum conveniens and so forth as to whether that case should proceed or not. I think certainly any invalidity aspect, I think the courts would think should proceed, because if there's the validity of a UK patent in question, then only the English court can actually invalidate that patent and get it knocked off the register. There's probably a bit more of a question mark about the infringement side. Would the EU member state court stay the proceedings in relation to the UK aspect? I mean, we're seeing that raised as a possibility in the UPC, where there's specific rules on stays. This CJU decision doesn't mention staying in the context of the third-party patents, but I think that may be just because the CJU were really looking at the fairly narrow question of whether there was anything in the Brussels regulation that prevented the EU court from going ahead with that assessment. And I don't think they really got into the ins and outs of how it might work if there were parallel litigation going on in the third country as well. I know a lot of people have asked about whether the UK courts are likely to grant anti-suit injunctions against the patentee from proceeding with the UK aspects in the EU member state court. I think that's a very open question, but I think it's worth noting that the test for an anti-suit injunction is pretty tough in the UK. They're not given out easily, and the party seeking it would have to show that the EU proceedings were vexatious, oppressive, or unconscionable. And again, I think that kind of shows the high threshold that you have to meet to be able to get an anti-suit injunction. One issue might be the order of the proceedings. So if the UK proceedings had been on foot first, and then the EU proceedings were started, I think you'd have a better chance, because you could certainly say, well, look, there's already an English action that needs to be protected, and the other party has deliberately brought this action in an EU member state court and is trying to get the UK issues dealt with there as well to try and scupper the UK action. If the English court were to grant an anti-suit injunction, would the EU member state court then try and grant an anti-suit injunction, again, as we're seeing in some of the Fran cases? These are all just a list of questions, which I appreciate is not particularly helpful for everyone at this stage, but I think they kind of highlight some of the issues that we're likely to get into with this parallel jurisdiction for certainly for infringement and validity of patents in third countries.
If I can just make a comment, and that is where you talk about parallel proceedings before an EU court and the UK court, then of course we also have to bear in mind that issues of lis pendens will come up, and that the court that has been seized secondly should actually stay the case, at least until the first court has decided whether or not it has jurisdiction to proceed, because of course we want to avoid parallel judgment on the same facts. So that would also play into this whole dynamics probably. Yeah,
absolutely. And I think it may strictly not be under the Brussels regulation with the UK, but the UK has rules about lis pendens and forum conveniens and all those sorts of points. So yeah, they would definitely, those issues I'm sure will come up. I think they're harder on, I think they're easier on the invalidity, because there's a clear difference in what the court is able to do in terms of the orders that it can make. On the infringement side, if there's an infringement action started in the EU court and then a DNI started in the UK court, I can see there's a much stronger argument there for a potential stay of the UK action pending the EU decision. But then the English judges certainly do view infringement and validity as being two sides of the same coin, and generally believe that those things should be dealt with together. And so that may have a factor in how the cases are characterized and treated. But yeah, I think we're going to see a whole world of jurisdiction type challenges, stays, and a lot of litigation game playing as to how these things get resolved. Brilliant. Nevin, would you like to say a few words about Turkey?
Yeah, thank you, Pete. Actually, this decision is a bit surprising for Turkish judges and for Turkish IP community, I think, because we are not EU members. So, I mean, also the Court of Justice says that the Brussels regulation cannot be applied to Turkey. But still, it makes like an argumentum ad contrario, and it says that still you can, the Swedish court, you can handle the infringement claims regarding the European patent, which is registered in Turkey. Actually, in Turkey, we are not real familiar with cross-border litigation when it comes to IP, but according to our according to our law, the Turkish courts shall be the jurisdiction of the Turkish court shall be determined by domestic jurisdiction rule. So, as Koen said, if the defendant is Turkish, I also think that the Turkish courts will be keen to handle even the patent cases if the defendant is Turkish, because it means that when it comes to of course, the infringement, not the validity, because also our law says that the validity should be, if you want to validate the patent, I don't think they will be really would like to deal with the validity issue. But when it comes to infringement, if the defendant is Turkish, maybe they will also would like to handle the case. As I said, according to our law, the Turkish courts, the jurisdiction of the Turkish courts shall be determined by domestic jurisdiction law. So when I made research, I came across to some the decisions regarding the recognition and enforcement of the foreign laws, foreign judgments. I think this will be the case here, because even if the Swedish court says there's an infringement regarding the Turkish patent, European patent, but it's Turkish patent because it's a bundle patent, and it's the Turkish law should be applied to this patent. And if Swedish court, even if the Swedish court applied to, by the way, I think if the Swedish courts will decide whether there's an infringement regarding Turkish patent or not, they should apply Turkish law, because the applicable laws should be Turkish law, because Turkish law protects this European patent. So if Swedish court applies Turkish law and if decides that there's an infringement, actually, I'm not sure whether this decision will be applied, will be enforceable in Turkey or not, because when I came across to some decisions, there are some decisions regarding the recognition and enforcement. Turkish judges, it was like actually they recognize some and enforce some decisions regarding the IP, but it's not like the infringement decision, because the claimant filed a case in Germany against the Turkish citizens, but the act was committed in Germany. I think this is the key point. The act was not committed in Turkey, so we are not sure what will be the position of Turkish courts if the act is committed in Turkey. In this example, the act was committed in Germany, and the court says, the German court says there's an infringement of the patent, and then I think in Germany for the expenses you have to file another case, and the claimant, the patent holder filed another case for the expenses, and then he came to Turkey and went to Turkish courts to enforce this decision, recognize and enforce this decision. There was a debate whether Turkish courts has to recognize and enforce the primary decision and then the second decision, which is regarding to the expenses, or the Turkish courts only can recognize and enforce the decision regarding the expenses. And after the long discussions between the first instance court and the Supreme Court, they came to conclusion that there is no need to recognize and enforce the first decision, but you can just recognize and enforce the decision regarding the expenses or maybe the compensation. But I'm not sure if it's like the if it says like you are obliged to pay this money to a party, I think it will be recognizable and enforceable in Turkey. But if there is something like infringement, like determination of infringement, I'm not sure what will be the reaction of Turkish court. As I said here, the Turkish court says that okay, I can recognize and enforce this decision because this decision will not affect the activity of Turkish citizens in Turkey, because the decision is regarding the activity of German courts in the activity of the Turkish citizens in Germany. So this is why German courts they are competent to handle this case. So this is why I can I can recognize and enforce this decision. So, but I think if a German company file a case against Turkish citizens in Germany because of the acts committed in Turkey, I think the Turkish courts will not recognize and enforce this decision regarding the infringement. When it comes to invalidity, of course, it's something else. Actually, when it comes to European Court of Justice, I think it's really as a citizen of non-EU state, it's interesting to see how this developed from the Painter case about the copyright and now we are discussing like the super sort of international authority of the European courts. I think it's really interesting, because as you will remember, in the Painter case, it was about copyright, but the court decided that no, you should go to Austria for the Austrian infringement, and to Germany for the German part infringement. And now we are discussing whether the Swedish court can decide on. Sorry, can you hear me now?
Yes,
okay,
we can.
Great. Okay, it's interesting to now we are discussing whether the Swedish court is like they have authority to handle the case, even if the act is committed in Turkey. Oh yeah, the Electrolux of course is a Swedish company, but still the act is committed in Turkey, and the patent is has been protected in Turkey. Actually, I don't know how the scope of protection and the doctrine of equivalence and all this kind of stuff, how they will apply and decide. So I'm really curious where we will go with this decision, because as I said, it's really interesting to follow the development or the amendments in the case law of the European Court of Justice, especially when I think about Roche decision. So, or even after the Roche, yeah, I think this is all I can say. If there are some questions, I will be happy to respond them. Also, I'm very curious. I may also have questions after if we respond to questions of the audience. Okay, thank you, everybody.
Thanks very much, Nevin. I think this really just illustrates that it's really going to be a bit of a minefield for some of these third-party courts in how they deal with this decision and what impact it has. Thank you for everyone that's put questions in the Q&A tab. We've got about 8 minutes. So I'll just kick off with a few of these. First question, are the panelists concerned that courts in other countries will assume similar rights to adjudicate validity on an inter-partes basis of national or European patents? For example, courts in China. Maybe just quickly give my personal view on that first. Absolutely. I think when we certainly from my own UK experience, when the UK courts have taken a fairly robust cross-border approach, such as in some of the FRAND cases, and determined global FRAND rates, we've absolutely seen other courts following suit and doing the same, and China is a classic example of that. So yes, I do think that if EU courts are going to start ruling on validity on an inter-partes basis of foreign IP rights, then I think, and if that becomes commonplace, I think we may see an adjustment in the approach of other courts to these international comity issues and potentially start doing the same thing. I don't know whether any of the other panelists have a comment on that.
Yes, Peter, this is why I have not added in my slide the reference to the US territory. Because I really have the same fear. It's clear that there are many interferences, and of course, if you try to widen your jurisdiction, then you have to wait for the same treatment from the other countries. So this is my personal view.
I think actually it may not have to go that far, because if the court, for instance, a Dutch court, grants an injunction that also applies to the UK because it is not convinced that there is a serious non-negligible chance that the patent would be revoked in a UK revocation action, then it could stop there, and it doesn't have to go further and say, I come to the finding that as between these parties, the UK part of the patent is invalid. That is no longer necessary to consider the relief that is claimed and potentially granted. So I think probably, but we'll have to see, the courts will also be a little bit careful in how they deal with these issues, even though the BSH decision perhaps opens the door to that possibility. I think in practice, it may not have to come that far.
Yeah, I hope you're right, Koen, and I hope the courts are a little bit more alive to international comity issues than it could be said the CJU's decision is. Nevin, say anything on that one?
Actually, this question, like, they reminds me about the data protection, GDPR, because we had the same discussion, I think, in Europe. If you want to like apply some rules to the US or to the world, then of course there will be a sort of reaction. And maybe in China or in the US, they would like to also decide on the European patents. So this is why I think, yeah, maybe this decision, like when I read it, it looks like it's that they decide according to law, but which law? Because we always have to interpret the law, and when it comes to, I think it's like sort of narrow interpretation of the articles. So this is why I hope that the EU courts will not go so far as Koen said.
Brilliant. Thanks, Nevin.
I think, sorry if I'm interrupting you, but I'm reading this very interesting question of Alexander Belinsky. Apologies if I have not pronounced in the proper way the name. Can you read it?
Sure. Yeah. Let me read it out. So, in accepting invalidity of an infringed patent in a defense in an infringement action, such decision would be bound only for the parties of the proceedings. In such a case, would the prior art or other arguments used for challenging validity of the patent be available for third parties?
Yes, I think that this is a very delicate point, because we are always very curious about what kind of evidence have been submitted in the parallel proceedings, especially when we are dealing on possible revocation of the patents. And I think that also the national system are very different. I mean, we have discussed a lot before the UPC about the transparency, but in some systems, for example, in Italy, it's not possible to obtain a copy of or in any case to know about the pieces of evidence that have been submitted by the parties during the proceedings. I don't know whether it's the same in UK or in the Netherlands. If everything is totally transparent.
It's pretty transparent in the UK. I mean, partly because in this scenario, there would be a full judgment from the UK court, which would set out exactly why the UK court thought the patent was invalid as between the parties. And so the prior art and all the arguments, or not necessarily all the arguments, but the conclusions from the court would be visible from that. And it's also possible to get hold of other court documents from the file. So yeah, I mean, although it's a ruling that's inter parties, if it's a public judgment, then it's out there to the world, and other parties can try and argue the same point in their proceedings.
Yes, so in UK, all the decisions are public.
Yeah.
Yeah, in Italy not. Okay.
Yeah, it's the same with us, and it will be clear from the judgment what the prior art is. So other parties should be able to find those documents. I can imagine that it might be different in a situation where the prior art is public prior use, and where additional evidence is needed to come to a finding of invalidity, and that evidence may not be accessible by third parties. Unlike in the UK or in the UPC, in Dutch litigation, the court documents, the submissions, and the evidence is not publicly available. You can get access by asking one of the parties, but if they don't give it to you, then the courts won't either. So you will have to find it on the basis of the judgment only.
Yeah, absolutely. I think this is why I personally struggle a little bit with this concept of an inter partes validity decision. What it means, and it's only binding as between the parties. But in a world that I'm used to, where you have a public judgment, it's it's going to be out there. So.
Yes, I think it's only to respect the authority, exclusive authority of a patent office in a national state to be responsible for the register and to update that so that it is reflected for everybody that the patent has been revoked by a court, and that's all. Otherwise, if the judgment is public and the reasoning is public, then clearly anyone could rely on it, and it would equally apply to anybody else.
Brilliant. All right. Well, thank you very much, everyone. We've had a few more questions come in, but I think we're out of time. So I would just like to thank all of the panelists. Thank you very much for your hard work in preparing for this. Personally, I thought it's been a very interesting discussion. Again, just a reminder to everyone about the AIPPI Congress in Yokohama, where there will be a panel on this topic. Registration for that opens on the 6th of May. And on the slide here, we're just showing a few upcoming AIPPI webinars over the next next few months. So a few things to watch out for. But yeah, thank you very much to the panelists and to AIPPI for organizing this, this webinar. Thank you.
Thank you very much.
Thank you, and thanks for moderating, Pete.
Thank you.